Avery pretrial. State of Wisconsin, Circuit Court, Manitowoc County, Branch 1. State of Wisconsin Plaintiff versus Stephen A. Avery, Defendant. Motion hearing. Case number 05-CF381. Date March 17, 2006. Before the Honorable Patrick L. Willis, Circuit Court Judge. Appearances: Kenneth R. Kratz and Norman Gahn, Special Prosecutors on behalf of the State of Wisconsin. Dean Arthur Strang and Jerome F. Buting, Attorneys at Law, on behalf of the defendant. Stephen A. Avery, defendant, appeared in person. The court at this time, the court calls State of Wisconsin versus Stephen Avery. It's case number 05-CF381. We're in court this morning to deal with a number of motions to be filed, or this afternoon. Will parties state their appearance for the record, please? Attorney Kratz, State of Wisconsin, appears by Calumet County District Attorney Ken Kratz. I appear as Special Prosecutor and lead counsel on the case. Seated with me is Norm Gahn, G-A-H-N, Assistant District Attorney from Milwaukee County. Mr. Gahn has been appointed by this court also as Special Prosecutor. The record should further reflect that Jeff Rolick, Assistant District Attorney from Calumet County, is also present in the courtroom. Attorney Buting, good afternoon, Your Honor. This is Attorney Jerome Buting of Buting and Williams, appearing with Mr. Avery. I'm co-counsel. Attorney Strang, and good afternoon as well. Stephen Avery is here to the far right at the table. Dean Strang of Burley, Burish, Stratton, on his behalf as well. The court, very well. I will indicate for the record that I have met with counsel briefly in chambers before beginning today. The first order of business is that we're going to take up is the defendant's motion for order limiting public disclosure. And I also indicate for the record that I had a brief telephone conference with counsel about this motion a week or so ago. I indicated at that time that I believed that under Supreme Court Rule 23.6, that it's the court's understanding that further trial publicity in the form of press release or other conversations with the press by counsel would be extremely limited by that rule. And I'm encouraged that the attorneys meet with each other and try to work out an agreement for any press contacts that they felt were necessary before the court would take up the issue as a contested matter. But I can indicate for the benefit of everyone, under that rule, the circumstances in which counsel or either party are permitted to communicate with the press during the course of a legal proceedings are quite limited, and the court expects, and I received assurances from attorneys from both sides, that they are fully aware of that rule and intend to comply with it. There are some exceptions to that rule that apply, including discussion regarding information that's contained in the public records. And it's my understanding from speaking with the attorneys that's the matter they are intending to meet with each other about to reach an agreement. Counsel, I will give each of you a chance to comment on the record and confirm that fact. Attorney Kratz, Judge, I do confirm that we have discussed this matter. Mr. Strang and I think, are very close in our positions regarding Rule 3.6 and public dissemination of information. I'm quite confident that should there be any need for additional information, or should there need to be an agreement reached on filing of public information, that can be accomplished between Mr. Strang and myself. The court, Mr. Strang, Attorney Strang, I think now that the court has reiterated the requirements of the Supreme Court Rule 23.6, and both counsel have acknowledged those that the court at the moment need take no further action on that motion. I would add that it's my recollection and understanding in the course of an off-the-record conversation that the state agreed that for purposes of this motion, an agreement such as it is that we have reached, that the Calumet County Sheriff, other agents of the state or Sheriff's Department would be embraced within the scope of that agreement. Like Mr. Kratz, I also think that with a little bit of further talking, we ought not have difficulty reaching some understanding on future filings or invited response for that matter, which is something that I understand Mr. Kratz also thinks worthy of discussion, and I'm happy to do that. The court. Mr. Kratz, is that correct? Attorney Kratz. That is, Judge. The court, all right. The court, for the time being at least, will hold that motion in abeyance with the consent of the parties, and hopefully you will be able to come to an agreement that will resolve the matter. The next motion has to do with the state's motion to amend the complaint and the information in this case and the filing and the opposition of that motion from the defense. I received both the state's request to amend and a memorandum in opposition from the defense. Before I get to you, Mr. Strang, I guess technically it's Mr. Kratz's motion to amend. Attorney Strang, and I wondered if I might have a moment's indulgence, since we're being broadcast, as I understand, and maybe streamed or whatever the word is on the web. I wonder if the court perhaps ought not address the media rules here, particularly intrusion into the counsel table of either side, filming during recesses, that sort of thing, before we move forward. The court, right. It was brought to my attention, and normally we have been dealing with the media matters through the media coordinator and representatives of the television broadcast stations, and there are a few things that counsel asked me to bring up, which I will later. The one that should be brought up immediately is that papers that are on the desk of either counsel often contain privileged information. So I'm going to ask the cameras who are present in the courtroom, or specifically the video camera, not zoom in on papers on tables which may be confidential. Is that what you're looking for today, Mr. Strang? Attorney Strang, that and the recess issue, but the court can deal with that at the time of its choice. The court, Mr. Kratz, I will hear from you then first on your request to amend the complaint. Attorney Kratz, thank you, Judge. As the court knows, the state has filed a motion to both amend the criminal complaint and the criminal information, which is in the formal charging document in felony prosecutions. The state has cited two separate cases authorizing, alternatively, the filing of the amended complaint and also the requirement or lack of requirement for an additional preliminary hearing upon the filing of new charges. The state reiterates that these new offenses charging Mr. Avery with 3 separate counts, including first-degree sexual assault, false imprisonment, and kidnapping, are not wholly unrelated to the original series of charges. I understand that Mr. Strang has filed with the court a motion challenging not the timing of the filings, but the sufficiency of the information contained in the complaint. And with the approval of the court, I will address those issues at this time, unless, of course, the court wants me to wait until Mr. Strang makes his argument. I have received his written argument, and I'm prepared to address the sufficiency of the complaint argument at this time, if the court would prefer I do that. The court, all right, Mr. Strang, as we discussed in chambers, it's my understanding the defense is not challenging the state's right to file at this time an amended complaint and information, but rather the sufficiency of the amended complaint and information that's been proposed. Is that correct? Attorney Strang, that's the bottom line on that point. The state, of course, needs leave of the court to file an amended complaint, or for that matter, an amended information. Leave would be withheld if the timing or some other aspect of filing were prejudicial to defense in and of itself, and it's not. That's not my concern. It's really the reliability or the sufficiency of the complaint which I am concerned. The court, all right, I'm not sure which one of you wishes to be heard first. Mr. Kratz is proposing the amendment, and I'm sure he feels that the amended complaint with the language included is sufficient. But Mr. Kratz, I will, since it's your motion, I'm going to let you start and briefly summarize for the court why you feel that is, and then I will hear from Mr. Strang. Attorney Kratz, thank you, Judge. Your Honor, as this court knows, any complaint needs to present probable cause or proof to the level of probable cause, which requires the court to look at the facts contained within the 4 corners of the complaint, together with any reasonable inferences that may be drawn therein. Mr. Strang has complained about the sufficiency of the information in the complaint. I might add that Mr. Strang, in his written motion, and in his written pleadings, as well as other information, contains a great deal of criticism for the state providing too much information within the 4 corners of the amended complaint. But this court understands that the reliability of information within the 4 corners of the complaint is something that the court must find. And so the state, in providing the detail that it did, argues that this was necessary, absolutely required for this court to make that finding of reliability. Mr. Strang also argues that there are no claims of physical evidence or other corroboration in the amended complaint. The state obviously disagrees. There's a lengthy list of physical evidence that has been recovered, that was seized, and in fact analyzed in this case, which is all recited in the amended complaint. I'm not going to go item by item, but the statement of now co-actor Brendan Dassey, in his recounting of the behavior of himself and Mr. Avery that ultimately led to the death of Teresa Halbach, as well as other criminal behavior, is quite detailed indeed. The state does argue, Judge, that within those details, as I have mentioned, those details are corroborated by physical evidence, which is recited in the court within the four corners of the complaint. Finally, Mr. Strang argues that if Dassey's statement alone was the basis for this particular prosecution, that at trial it could not stand beside the Lilly, L-I-L-L-Y, as well as the Crawford, C-R-A-W-F-O-R-D, cases, and that the state concedes that at trial, if the state intended to convict Mr. Avery on Mr. Dassey's statements alone, without any physical evidence, that they may be unable to do so. Or if we attempted to introduce a co-actor statement without an opportunity to cross-examine, that would also be problematic, requires an advanced ruling. But those are trial issues, Judge. These are issues that apply to Sixth Amendment confrontation and are unique to trial. I think Mr. Strang, at page 9 of his brief, concedes that although the rules apply to trial and not an analysis under the criminal complaint, Mr. Strang invites this court to nonetheless throw out the complaint just in case the state intended to only provide that statement. Well, the state does not intend to provide only that evidence at trial, but again, these are trial arguments. It has nothing to do with the criminal complaint. When the court reviews the four corners of the criminal complaint, it will find probable cause that the defendant committed each of the violations as set forth. As I have recited in the Burke, B-U-R-K-E case, an additional preliminary hearing is not required based upon the connection or nexus of the 6 criminal behaviors that are alleged, that is, they are not wholly unrelated. We will ask the court to grant leave to file that amended complaint and information. Thank you, Judge. The court. All right, Mr. Strang, Attorney Strang. The proposed amended complaint founder is not, of course, on a posit of default, but rather on the unreliability of the detail that is included. Let me walk sequentially here through the problem that confronts the court. There was an original complaint, of course, that started this criminal case back in November. It charged 3 crimes: first-degree intentional homicide, mutilation of a corpse, felon in possession of a firearm. The time to challenge that complaint or probable cause showing is gone. It's established for the purposes of this motion and today's proceedings. I raise it because now it's proposed amended complaint that state has incorporated by reference, as lawyers are fond of saying, the factual allegations in the original complaint. So let's start there. No one presumably at the table to my left, would contend that the original complaint without the March 2nd or whenever it was additions made out of probable cause to believe that Stephen Avery committed first-degree sexual assault. No one, I assume, in the courtroom would contend that the original complaint's factual basis made out probable cause or anything close to it on kidnapping or false imprisonment, which are the other 2 new counts in the proposed amended complaint. So the incorporation of the factual basis in this first complaint, while I acknowledge it, really adds nothing at all to our problem here today, focusing maybe most usefully on the first-degree sexual assault allegation that the state wishes to toss in the mix of this case now. What is new is the proposed amended complaint, as counsel acknowledges, is a statement that Brendan Dassey gave, evidently to law enforcement officers, in response to law enforcement questioning out of Stephen Avery's presence. And now that the state would, would like to use it as a reliable basis for finding that he probably committed first-degree sexual assault and kidnapping, false imprisonment. Again, it's not the lack of detail. There's a great deal of ugly detail that the police say Mr. Dassey provided, and the reliability as to Stephen Avery, that's the problem. I'm delighted to hear counsel acknowledge in a fashion here today that the Dassey statement would be inadmissible, not allowed at trial against Mr. Avery, absent a chance to cross-examine Mr. Dassey in that witness chair or some similar chair, not admissible evidence against him. I also acknowledge that a complaint can include the intimate inadmissibility. The court can look at that within the four corners of that complaint, but as Knudson, Knudson, and a variety of other Wisconsin decisions, at least back to 1968 with State EX REL Evanow, EVANOW against Seraphim, SERAPHIM, and I'm sure decisions before that, before I was born. As the court knows, hearsay or not, the factual assertions in the complaint have to be reliable. The state here in the complaint alleges that these presumptively reliable and presumed truthful and reliable. I think this is the exact wording of the complaint. In fact, of course, the presumption is just the opposite. It's not just the opposite as a matter of law. The U.S. Supreme Court has made that clear, and at least by Bruton, Bruton, back in 1968. While we're on the 1968 cases, Lee, Williamson, and Lilly. This is sort of a beyond repetition at this point. This is really very clearly established that when an accomplice or someone claims he's an accomplice is questioned by police and says, yeah, I was involved, but he was involved too. He did this and he did that, and he points to someone else. That's unreliable stuff. It's blame shifting. It's literally finger pointing, and it's a very effective way for an accomplice, caught cold or not, to sound credible by acknowledging some involvement, but to lay off blame, in large part, on another person. While the risk of that particularly high when we're talking about a 16-year-old boy who may be slow and being questioned by two police officers, presumably without a parent or lawyer around. Yes, the risk of that are particularly high, and if we get into the specifics on reliability. But the courts, including the Wisconsin Court of Appeals and Myron, MYREN, which Mr. Buting and I have cited, has been very clear that this stuff is inherently suspect, inherently unreliable, presumptively unreliable, just to quote bits and pieces. So the state really can't claim the presumption that the amendment tenders. Neither does the complaint offer anything more than a presumption that Brendan Dassey's statements are truthful and reliable, not as to Brendan Dassey, but as to Stephen Avery. And that's where the problem is. They simply are not, as a matter of law, reliable as to Stephen Avery. Hence the motion asking the court not to strike the original three charges, of course, but to deny the state leave here to find the three new charges. Timing is not prejudicial. That's not the issue, as we have agreed. The reliability, or rather the unreliability, of the entire factual basis here, there being as to first-degree sexual assault, kidnapping, and false imprisonment. Nothing but an inadmissible, unreliable statement by Brendan Dassey to support this complaint. Allowing it to be filed would require the court not only later, when I file a motion challenging the probable cause, to dismiss those three counts. Again, there's no reason to do that. The court, on the grounds we have articulated, ought to deny leave to file this proposed amended complaint, at least as to the three new charges. That ruling would necessarily not moot inquiry into what is procedurally a subsequent document in Wisconsin criminal courts, which is an amended information. We also don't have to get to the questions of preliminary examination if the court denies leave to file the amended complaint, because there's nothing on which to have a preliminary examination at that point. I could pause and let the court say something, but I will note that I very much disagree for this amended complaint to be filed with the leave of the court, and then to withstand a motion to dismiss on a probable cause grounds. I very much disagree that the preliminary examination would be unnecessary legally as to those three new counts. And I can get into Burke, B-U-R-K-E, and more illuminating, Bailey, B-A-I-L-E-Y, a decision that Burke extends or at least endorsed. It's the facts of both of those cases suggest why, although the new counts are not wholly unrelated to evidence adduced at the preliminary examination here, these new counts would be wholly unrelated, at least on the first-degree sexual assault and the kidnapping. May not need to get there, so I will yield the microphone. The court, Mr. Kratz, anything in rebuttal? Attorney Kratz, just a couple of things briefly, Judge. Once again, if Mr. Strang and the defense is allowed to extend these trial confrontations principles to the criminal complaint analysis, state argues that you would never, or at least it would be very difficult to ever charge co-defendants, at least when one of the co-defendants makes a statement and the other does not. Again, they are simply not complaint principles. These are trial confrontation principles. Let me also talk then to the reliability question that Mr. Strang raises. Reliability of the statements of the co-defendant in Lilly, L-I-L-L-Y, and the other cases cited by Mr. Strang. Don't just inculpate the co-defendant. Don't just point the finger at someone else, but they are also meant to exonerate the defendant. That's not what we have here. Mr. Dassey's statement is in no respect, at least as cited in the amended complaint, intended to exonerate Mr. Dassey at all. Mr. Dassey inculpates himself. He says, I acted together with my uncle, Stephen Avery, without threat, without reprisal, knowingly and voluntarily engaging in the same kinds of behaviors. So when a suspect makes a statement that against their own penal interest, they deserve reliability. That is much distinguished from the kinds of statements, again, that were offered in Lilly and others. That's all I got, Judge. Thank you. The court. All right. First of all, there have been a number of reported decisions, especially United States Supreme Court decisions in recent years involving the admissibility of the statements of a co-defendant at trial, where the state seeks to introduce the statement not through the actual person or of the co-defendant, but as hearsay testimony. And the law in that regard has changed a good deal in recent years against the state in favor of the defense, culminating with the Crawford case, C-R-A-W-F-O-R-D, which held, as close as you can, as a black letter rule that if a co-defendant's testimony is going to be used against the defendant, the co-defendant in virtually all cases has to testify. But I think it's dangerous to simply equate those cases to the situation where you are dealing with a complaint and whether or not the statements of a co-defendant can be used as basis for a complaint. Closest case from Wisconsin on the facts that I could find is a 1974 case called Ruff versus State, R-U-F-F, which dealt precisely with this issue. That is, whether or not a complaint can be based on the statement of a co-defendant that implicated the defendant. I will read a little bit from the decision. The court asked, was the complaint legally sufficient to establish probable cause? The defendant admits the sufficiency of the complaint to establish probable cause that the alleged crimes had been committed, but challenges the deficiency to establish probable cause that the defendant committed crimes. The part of the complaint which names the defendant is based upon statements made to the police officers by the defendant's accomplices, Charles Flowers and Willie Payne. Such statements were hearsay, but a criminal complaint may be based on hearsay. The court goes on in that case to hold that the statements against penal interest made by a co-defendant can be used as a basis for probable cause and a complaint where the statement is not the statement of the co-defendant essentially attempted to exculpate himself. That is, there can be cases where a co-defendant is simply trying to blame someone else. But where the statements are interrelated such that the co-defendant is implicating himself at the same time he's implicating someone else, I believe the law in Wisconsin, as it applies to the criminal complaints, remains that such statements can be used when considered in context, they have sufficient indicia of reliability. And based on my review of the complaint, I do believe That's the case here. I recognize that some of the rationale that's been criticized in the cases have led to testimony in those cases not being admitted where it doesn't come from the co-defendant himself at trial, thus based primarily on confrontation clause issues under the United States Constitution. And I'm not aware of any decision that has not been used the same rationale to say that the statements of co-defendant cannot be used to supply probable cause in a complaint. So for that reason, I believe that the statement of Mr. Dassey contained in the proposed amended complaint can be used as a basis for the complaint. And I believe that with those statements, the complaints are sufficient as they have been filed. I believe that's the only basis on which amended complaint is really being challenged. So the court is going to grant the state's motion to file the amended complaint. I think implicit in Mr. Strang's argument is that he may have other issues related to that matter that he wishes to argue. So, Mr. Kratz, I will direct you to prepare the order allowing you to file your amended complaint. And Mr. Strang, I will give you the opportunity to file additional pleadings if you wish regarding whether your client is entitled to a preliminary examination based on the amended complaint. Attorney Strang, I can do that within 10 days after the order is signed, if that's sufficient for the court. The court, all right, I'll allow you to do that. At the end of today's proceedings, I can see we may have to do some scheduling, but for now, I will give you 10 days to file your motion. Is that in that respect? Let me ask you this. Do the parties anticipate any additional issues other than the defendant's right to a preliminary examination on the amended complaint relating strictly to the complaint and the proposed amended information? Attorney Strang, we can short circuit one I could see, which is I will move now to dismiss the 3 new counts and one for a probable cause, relying on the arguments that I've already made. And if I heard correctly, the court ruled that with the Dassey's statement in as a factual basis, there is probable cause. I disagree, and I will make the motion for the purposes of making it clear that I do want the 3 counts dismissed once the amended complaint is filed. The court, all right. Attorney Strang, but don't need to brief it separately. The court, okay. Anything further on the complaint issue before we move on? Attorney Kratz, no. The court, all right. The next issue the court will take up is the defendant's motion to assure fair forensic testing, which involves a request by the defense to either be present when the state lab performs analysis on items that have been seized in the course of the investigation in this case, or in the alternative, to have testing procedures videotaped. And if I understand correctly, Mr. Beauty, you will be making the defense argument on this issue. Attorney Beauty, yes, Your Honor. The court, I will hear from you now at this time. Attorney Beauty, the defense motion is somewhat unusual, but I think given the nature of this case and its unique history, I think it's appropriate, especially in light of the concerns that were raised earlier before either Mr. Strang or myself became involved in the case about our possible bias from law enforcement, that I would think the state would actually welcome efforts to make the testing process more transparent. And that would be by allowing a defense representative to be present during any portions of the testing where they are handled, where the evidence gets handled by the analyst or technicians and or videotaped those portions of the testing process to ensure or at least limit the possibility of there being any contamination that may occur of the evidence in the lab once it gets there, either accidental or otherwise. I believe that, although there are no cases that specifically address this issue, I think the court does have authority to do so by considering statutes 165.79 and 971.23 together. The first allows the court to order the crime lab to perform tests on the defense behalf under certain circumstances. And if the court has the authority to do that, then this is a lesser remedy or request, which is simply to allow the defense to participate in observing, not to interfere with, the process itself, not to necessarily be present during the generation of the results of the test, which are disclosed anyway under 971.23. And all this would do is move up the time when those rules get disclosed. That is, at the time that the state learns them, the defense representative will also be there and learn them. There are, I think, very unusual circumstances in this case that warrant that. The remedy that the state suggests in their response objecting to our motion is independent testing. Independent testing can work in some instances and to some degree, but not if the material is already contaminated. A repeated independent test of contaminated evidence does nothing towards getting at the truth. It simply repeats or confirms the original erroneous results. The state also suggests that, in addition to that, by the way, having independent tests done subsequent to the state's test can also build an additional delay. I don't know how long it's going to take for the state to complete the test that they have not yet done. That would be presumably on the items which were seized on the March 2nd. I think it was search warrant. But an independent test would necessarily have to take place after that, and that could be a while. Mr. Avery is at least presently incarcerated. The bail issue we'll be dealing with later, but if he remains incarcerated, then that works to his disadvantage by requiring him to sit in jail longer, just because the state resists transparency in the process at this point, allowing a defense view of what goes on in the crime lab. So independent testing is not an adequate remedy to the concerns of the defense has in this particular case. The state also, in its written objection, complained that somehow this would jeopardize the accreditation of the state crime lab if an outside observer were allowed in. And I don't see that at all. Nothing they cite in their written brief indicates that. Accreditations require that a lab comply with security and control methods, which are not always done, by the way, despite the fact that they are supposed to be accredited. But those could be complied with very easily with a defense expert who might be present. I have spoken with a defense expert who has done this in other labs and in various states, including recently in Illinois. I believe also in Maine. It's done very easily. He is clothed in surgical type scrubs, mask, same way that a state analyst would be. He also has no objection to the state's concern that the crime lab has a process whereby their staff provides their own DNA genotype, so that in the event the results come up or would come up that would show that there's some other DNA in it, if it turns out to be the analyst, then it can be discarded as evidence, as indication or contamination. The defense expert would also be willing to do that. So I don't see anything about the way that the crime lab is set up that its testing would prohibit or make it somehow a threat or jeopardy to their accreditation to allow a defense representative to be present simply observing what's going on. The state also cites in their written opposition a number of older cases where the courts did rule that it was not, or they denied defense motion to do similar types of observations. But one reason that this motion is brought up in this case is because of what we have learned, what the public has learned about crime labs all over the nation in the last 5-6 years. I cite some law review articles that talk about these studies that have been done. Now, 17 states, crime labs in 17 different states, have been found to have either had fraudulent behavior by some of the analysts or erroneous test results, incompetence, everything. The entire spectrum of problem that result in false tests that in some instances in Kansas result in the correct suspect being released, going out and committing another offense, and in other instances, innocent people being wrongly identified through DNA testing, only later, fortuitously, was determined that the mistake was made. The FBI lab, once considered the most prestigious elite lab in the world, went through a horrible scandal of disclosure of not just mistakes, and there were many instances of that, but also deliberate, fraudulent conduct resulting in one of their analysts being convicted of a misdemeanor for fraudulent reporting on DNA reports. That went on for 2 years before the lab discovered it. Now I'm sure that the state will say more differently. This is Wisconsin, and we have a very fine lab here. It's never been proven to have been fraudulently or erroneously come up with test results that have affected the case. But I'm also quite sure that the prosecutors and courts public will believe that in all the other states in each of those cases. And yet we know otherwise. We now know that these kinds of mistakes do take place, and there is a worldwide discussion on what to do about the problem with the crime labs. DNA evidence has considered this problem with programs like CSI on TV and other things like that, considered this the ultimate proof the pristine evidence one way or the other. That's only true so much as crime labs in this country and this state are competent, fair, and able to produce correct results. Therefore, what we're suggesting is, given the implications of what has gone on in this case, or what was implied anyway earlier before we became involved, we think the best way to resolve, to assure that doesn't extend further into the testing process, to simply allow transparency. That's all we're asking, no interference, just transparency to allow defense representative to be present during the handling of the evidence, or in the alternative, a less favored alternative, but at minimum, something that certainly wouldn't cause any contamination would be to videotape at any time when the analysts are handling the evidence itself. There's periods of time when it's sort of cooking in an incubator, and it wouldn't need to be filming that portion, but when it's taken out, when it's moved from one step in the process to the next, that could certainly be recorded and preserved, and that would, I think, lessen the likelihood of there being any implications of wrongdoing or mistakes down the road. I think there's authority for it. It's in the court's discretion to grant it, and that's what we ask. Thank you. The court. All right, Mr. Strang, do I understand that Mr. Gahn is going to be addressing this issue? Mr. Kratz, I'm sorry. Attorney Kratz. Yes, Mr. Gahn. To be continued in part 2.